Now we're going to talk about assault and battery. These two crimes, they generally go hand in hand, and in most jurisdictions, including New York, they're recognized together as one crime called assault. And then they're graded per the criminal act involved. Example, an unwanted slap to the face will be a lower level assault compared to a bat over the head. So, but there are states that distinguish the two between assault and battery, and I'm going to do that here. So knowing the difference is important. I think the book muddies the distinction, so I hope that I make it clear here. And I'm going to start with assault. I think the book starts with battery, but I think starting with assault is the better way to go. So you have it both ways, and then you can decide which way you like it. So assault, what is it? It's an intentional, or knowingly, but it's an intentional act. It's an unexcused act that creates in another individual a reasonable apprehension of fear of immediate harmful or offensive contact. That's an assault. So you need a few things. You need an intentional, unexcused act that creates in a person a reasonable apprehension or fear of immediate harmful or offensive contact. So we got a couple things happening. And I'm going to note that they distinguish between apprehension and fear. Fear is not the same as apprehension. Apprehension is if the contact is such that a reasonable person would want to avoid it. That's when we have apprehension. Oh, actually, there's another component. Sorry. We have a reasonable person who wants to avoid it, and there's a reasonable basis for believing the contact's going to occur. So you need 2 points for apprehension. If the contact is of such that a reasonable person, what would the person do in a similar situation? A reasonable person would want to avoid it, and there's a reasonable basis for believing that that contact will occur. It doesn't matter if they're afraid or not. You want to avoid an unwanted, offensive contact, and there's a reasonable belief that that's about to occur. You don't even have to touch somebody. This crime of assault does not result in touching. It focuses on the mind of the victim. Okay? So let's look at battery. Then we're going to do examples. So battery is the follow through, right? It's the unexcused and harmful or offensive physical contact intentionally performed. The slightest of touching can be a battery if an injury occurs. And it has to be, and when we're talking about offensive, to a person of ordinary sensibilities. So we got a harmful or offensive physical contact, and that, if we're talking about offensive, it's offensive, has to be to a person of ordinary sensibilities. If we were in a classroom and I walk up to you and I slap you in the head, that is a harmful physical contact, and it could be offensive too. You could think that was offensive. But if I walk up to you and I put my hand on your shoulder and I say, nice job, and you find that offensive, would that be particularly offensive to a person of ordinary sensibilities? Probably not. You might be offended by that, but an ordinary person of sensibilities wouldn't be. So let's look at some contacts here, or some examples. Ivan enters the Crown Convenience, which is a small neighborhood store. Pulling out a handgun, he demands the money from the cash register from Jean, the store clerk. Once Jean gives Ivan the money, he shoots her. Do we have an assault? Yes, we do. Where do we have the assault? I hope you're talking at my screen. When he sticks the gun and he's pulls out a handgun. He's demanding money from her. Wouldn't that be creating apprehension or even fear in an individual? He doesn't have to have a follow through. In some states, this is an assault, creating the apprehension intentionally in another. And then she hands over the money and he shoots her. So do we have a battery? Yes, now we have the harmful contact. See how they go together, the assault and battery? You might see that in some states they might charge it that way. We have an assault and a battery. In New York, that is just the two combination together, some form of assault. At what level it is, it depends on what in this case it's tied to a robbery, but we're not going to go down that avenue. This is for the example of sorting out assault and battery. Let's try another. You borrowed money from me a month ago. You were supposed to pay me in a week. I call you up today and demand my money, and I conclude with, if you don't pay me within 24 hours, I'll come get you. I'll go get you. Is this an assault? This is not an assault. You might be, worried? Maybe it creates a little apprehension, but this is a threat to the future. This is not the immediacy, right? You have to have the creation of apprehension or fear, but you also have to have the second component that it's about to come. Something, the harmful, unwanted context is about to come, and it's not in this instance. Threats in the future are not enough. Mere words are not alone. You need an actual affirmative act to get you to the battery, the actual contact. That might be a battery, but there wouldn't be an assault. And it's not assault in this case, okay? So we don't have either or here, unless I come get you. If I come and get you and I hit you with a bat, do I have battery? Yes, I have a battery. Do I have an assault? No, because I don't have what comes first, the apprehension. So they can be charged separately as well. But as you can see, it's kind of, I find that the way New York State has it, it's kind of an all-in-one. And if you don't do the follow-through, let's think about this one right here. We'll talk about it at the end, but let's see if we can come up with the answer. What if we don't have the follow-through? What if we have the guy with the gun going into the clerk and putting the gun in her face? And then what if he shoots and he misses her? In New York State, I told you they don't have a battery. And of course, we don't have a harmful contact, so we don't have battery. What might we have? I hope you're saying attempted battery. We'll talk a little bit more about attempted battery towards the end. So Mary's walking down the street, and Bob runs up behind her and snatches her purse off her shoulder, causing it to rip out of the socket. Do we have an assault? No, we don't have an assault. There's no creation of apprehension or fear in Mary because she doesn't know it's coming, right? She doesn't know it's coming. Do we have the battery? Yes, right? She rips her arm out of the socket, but technically we don't need him to actually touch her body by grabbing the purse, and he's got his hand on the purse, not on Mary, and he yanks her arm and the shoulder rips out. We still have a battery. What if Bob, let's see, do I have a slide on this one? Yep. What if Bob throws a rock, intentionally throws a rock in her direction, intentionally? His plan is to hit her. He doesn't like Mary. He throws a rock and it hits her. Is that a battery? Yes, that's a battery. When you set something in motion, you use something that contacts another. That is also considered a battery. What if he throws the rock and misses Mary? He intends to throw the rock to hit Mary, but he misses. She bends over right at that point. She bends over to pick up a penny and misses. That's an attempted battery. I think we talked about that example. Are there any defenses? Think there's any defenses to a battery, assault and battery? How about justification? Self-defense? That would work in this instance. We won't delve into it, but I'll let you guys make the connection. We covered self-defense in some great detail. Any other ones? Could you ever consent to a battery or that harmful or offensive contact? Sure you can. You can consent. It's a defense as long as that consent was freely and intelligently given. How do you give consent? You can do it expressly. Yeah, I consent to this. Or by some voluntary conduct or participation. I think the prime example we've used in this consent example, especially as it's related to assault, is if you are playing contact sports, can't sue for assault. If you're playing hockey and you get checked into a board and you get hurt, it's not, you've consented to be there. How about a boxer? The same thing. But consent must be, like I said, freely and intelligently given. Now I'm just going to right back on this attempted battery. I've been bringing it up. You have to keep attempt in the back of your mind. I know we've talked about it generally as its own crime, but it applies as we work through some of these crimes. It works. It's here. You can have an attempted battery. Bob intentionally throws a rock at Mary, and while she is walking her dog, it hits her in her head. We have a battery. In New York, we call it assault. If at that moment, I just gave this example, if at that moment before impact she bends over to pick up a penny off the ground and it shoots over her head, is he off the hook? No, because he intentionally meant to hit her. It didn't complete the act. And you'd have to go through the elements of intent, attempted, using one of those tests. But this is, I think, under all of those tests, this would get you attempt in each case. Grading our assaults and batteries. It's dependent on the jurisdiction. It could be a misdemeanor in some states. I think New Hampshire calls the lowest level of assault, which, by the way, they treat assault and battery the same, is a simple. They call it a simple assault. So, as I indicated, the grade of the crime evaluates depending on the type of harm involved. Hence, if it increases the sentence, just to give you, put it into context, I will give you the New York State assault statutes. They're pretty straightforward, and you climb the ladder. Harassment is a violation. It's not even a crime. Remember, we talked about we have violations, misdemeanors, felonies. A harassment is a violation. That's our lowest level of assault type case in the assault category. And it involves striking, shoving, kicking, or otherwise subjecting another to physical contact. So you actually have to make contact. It's kind of a lesser version of a battery. We call it harassment. So if you go up to your arch enemy who kind of ticked you off and you slap him in the face, you can be charged with harassment. And then our next level is an assault third in New York State. It's an A misdemeanor. And basically what it says is if you intend to cause physical injury. When you intend to cause physical injury. As you notice in the harassment, you don't have to attend any sort of thing. You just have to do one of those things. You have to intentionally strike, shove, kick, or otherwise subject someone to physical contact. So intend to cause physical injury, you punch your arch enemy in the face and give him a black eye, fat lip, some sort of cut or laceration will do it, a bruise to the stomach or the rib area. And then we have assault second, which jumps really far. We go from a Class A misdemeanor on an assault third to a Class D felony. So we've skipped the E, we go right to D. I said assistant. It's assault in the second degree. And the defendant has to, I keep saying you, I apologize, intends to cause serious physical injury. Those types of things that have been considered a serious physical injury: a broken nose, a broken limb of some sort, a loss of a limb, a permanent injury, throwing something in somebody's face and their eyes and causing blindness. And then we have assault in the first degree. And I'm going to kind of recant on my last example. I was jumping ahead as I'm looking on my list of examples. That last one of throwing something in somebody's face and causing their eyes to blindness, that is under our assault in the first degree category, which jumps to a B felony, and that intends to cause serious physical injury using a dangerous instrument or deadly weapon. So if you picked up something off the table and you think it's bleach, or it's bleach, and you throw it in somebody's face, even if you don't know that's bleach, if your intent is to throw something in somebody's face and it causes blindness, that is using a dangerous instrument to cause serious physical injury, and that would get someone an assault first charge. And to give you an idea of how these sentences go up with a harassment, it's generally a fine of anywhere between $0 and $250. An assault third misdemeanor, the top punishment is a year in the county jail. Assault in the second degree could get a lengthy term of probation up to 5 years, but there is a prison sentence that could be imposed. It's the minimum sentence. It's 1 1/3 to 3 years to a maximum of 2 1/3 to 7 years. So that's a big window a judge can impose on there. I don't think we're talking about sentencings specifically in this course, but just so you can get an idea of how they elevate, and if the assault in the first degree, someone can get up to 25 years on that in prison. And it would be mandatory, some term of mandatory prison, because it's a B felony. So those are the assault crimes, with a sneak peek at the New York assault crimes. And we are going to move on to stalking.